For our last speakers of the day, we have a panel, and in this panel, we talk about an area that I think people are less aware of than any other area in the DSM-5, and that is discovering what judges need to know when ruling on decision-making supports for people with intellectual and developmental disability. Our moderator for this panel is Clair Benitez. Clair started at the helm of the newly formed Office of Disability Services Coordination, ODSC, at the Health and Human Services Commission, HHSC, in May 2021. ODSC aims to improve the outcomes for Texans with disabilities by coordinating across and within HHS programs, robust stakeholder engagement, and focusing on research and strategic initiatives that propel or inform the work of ODSC. Serving on the panel are as follows. Kent Allen has over 30 years of experience in the field of IDD as well as behavioral health services. He has worked in the public and private sector and is a certified person-centered thinking instructor. I could learn a lot from that. Mr. Allen teaches a set of value-based skills that reinforce learning and practices that help providers support people receiving services. Helping people get better lives has been his motivation, as he has spent most of his career helping people connect to services and supports. You gotta love him. Mr. Allen is currently the manager of the Intellectual and Developmental Disability Training Unit at HHS. And we have Cicely Reid, is the Pro-Bono coordinator and senior staff attorney at Disability Rights Texas. Ms. Reid works primarily with the Community Integration and Healthcare team on Medicaid appeals and the Employment, Voting Rights, and Accessibility team on Department of Justice complaints and other accessibility disputes and litigation. Ms. Reid also manages the Pro Bono program for the state and is responsible for the Pro Bono clinics and training programs. Her focus is recruiting and utilizing private law firm attorney volunteers to help litigate and resolve disability rights cases. We also have Teresa T.K. Reynolds, is a regional operations manager with the Health and Human Services Guardianship program, where she manages, trains, and educates a group of supervisors and staff. The staff oversees the daily lives and needs of multiple individuals within the guardianship program. Ms. Reynolds has over 33 years of experience working in the social services field, 23 of which have been with the guardianship program. Welcome, panel.
All right. Can you hear me? Oh, now you can. All right, thanks for joining us, the last session of the day. Hopefully my voice holds out. Last night was definitely a challenge, but go Astros. I see someone, there we go. All right, so thank you for joining us today. One of the things we really wanted to talk about was being able to profile each of our panelists. They serve in various capacities. However, they all have a common thread that supports folks in various ways. So various levels of support to make decisions, some formal and some informal. So formal, like learning how to, knowing to sign a medical consent, some informal about how to help someone explore a job. But what's most important is we'd like to gain perspective today from each panelist's role and share some related Texas legislation in this area. That the prompt was very well timed. There was definitely some things on the books, and I've been on the books for quite some time, that we want to get the word out on a little bit more. So first, Kent, I wanted to start with you. We titled our presentation, "The Dignity of Risk." And this is included in the title of the session. And what does this mean for folks in the audience in the context of the discussion that we're going to have today?
Yeah, well, I think it's important to recognize that kind of historically I think our society has always, when we think about people with intellectual and developmental disabilities, we've kind of had this way of wanting to overprotect. And, we think about people's rights and dignity. Well, for self-determination and for people to have self-esteem, it's essential for them to exercise their rights and take some risk. And if you think about it, all of us every day make choices, we take risks, and we learn from our mistakes. And sometimes, and usually it's an informed choice or a risk that we're taking. I like to look at this from a person-centered approach. Of course, with IDD services, that's a real big thing in how we do the training and really try to help people develop plans that are truly their plan. But one of the things that we teach is for service coordinators and providers is learning to identify like what's important to a person, but also what's important to them, but also what's important for them. And as y'all probably know, important for is really all about health and safety. So when you start identifying the things that people want to achieve and that are important to them, what we do is we balance that with things regarding health and safety. So they can make some choices and take some risk and learn from that, but we're always balancing that with health and safety. So, I think the bottom line is people want to have positive control over their life. And so I think when we think of dignity of risk, it is dignified and respectful to recognize that.
And Cicely, I want to come to you next. I think you've got some information to share as it relates to Texas legislation that's related in this area that really promotes that idea of dignity of risk when it comes to decision making.
Right. Thanks. Thank you so much for having me. So interestingly, Texas courts had over the years become fairly overwhelmed with guardianships because up until 2015, when the Texas legislature changed the estates code, once an individual with a disability transitioned from being a minor to being a young adult, really the only option that was available from a legal standpoint for them was to place them into a guardianship. The problem with that was for a lot of those young adults and other individuals in Texas with disabilities, a guardianship wasn't necessary for them to receive the support that they needed to live, fully integrated within the community. So a pilot program started in 2014 with Disability Rights Texas partnering up with the ARC and some other organizations, and it culminated in the Texas legislature amending the Texas Estates Code with Chapter 1357 in 2015. And Chapter 1357 really sort of allowed, it was the Supported Decision Making Act, and it was revolutionary in terms of changing the approach to giving individuals with disabilities options once they transition from being a minor into an adult, as well as other individuals with disabilities that may need some support in the community. They may need some resources, but they did not necessarily require full-on guardianship. So essentially what happened with the Supported Decision Making Act is that all Texas judges are now required to consider less restrictive alternatives to guardianship, including supported decision making, before granting a petition for guardianship and placing an individual with a disability into a guardianship. And Texas is one of the first, if not the first state in the country to codify this significant change. So what this meant was you now have an option for individuals with disabilities, and they can utilize the tools that are outlined in Chapter 1357, so that they're not necessarily placed into a guardianship where they lose all control over their own decision-making capacity, and they have no control over how they live their lives. So through supported decision-making agreements, powers of attorney, releases of information, and various community supports and services, assistive technology falls into this category, really it's a person-centered approach to designing a solution for each individual with a disability so that they can live in the community safely and also have the freedom and determination to make their own choices with the support of trusted loved ones in the community, family members, neighbors, things like that. So it's really a revolutionary change in the law, and it's made very significant differences and improvements in the lives of individuals with disabilities because they are, as Kent was mentioning, able to sort of participate in their own decision-making process and really just pursue their dreams and what they want for their lives and live safely in the community, but without such a heavy restriction as a guardianship, which is what the traditional move has been in the past.
And we wanted to play a quick video of Ricky's story. This was actually something that I think DRTX produced shortly after this legislation was changed to really, send the message home about what this really looks like, and especially highlighting someone that might be using a supported decision-making agreement today.
What is supported decision making? A message from Disability Rights Texas.
Hello, my name is Ricky Broussard, and I'm at Disability Rights Texas. I'm here to talk to you today about supported decision making.
Supported decision making is a way for people with disabilities to keep our rights and make our own choices with help from others instead of having a guardian who makes decisions for us. Guardianship.
People say guardians make it easier, but once you have a guardian, that guardian has control over you. A guardian is decided by a judge, and you do not have control over any important decisions that need to be made. It shouldn't be that way because it's about the individual's life. It's not about their life.
Under guardianship, you can lose the right to choose where you live, how you spend your money, who you spend your time with, and other important decisions. Supported decision making.
Supported decision making, it's all about the individual. It helps us make the right decision for ourselves in our life. If you need help making decisions, choose someone that you trust. It didn't have to be a family member. It could be somebody at school you trust or somebody at work you trust. After you choose somebody to support you, you tell them what you need support on and how they can help you. Some of the things that your supporter can help you do is go into the grocery store or make medical decisions or with where you live, or they could help over your finances. In my support team, I let everybody know, okay, this is what I need decisions on, and this is what I need you to help me with. After I hear the pros and cons of the decision, that's when I make the final decision on whatever choice I make. We all need help to make decisions. We have to make decisions every day. Your rights should not be taken away just because you need help.
To learn more, ask for the free book called Making My Own Choices by calling 512-454-4816 or toll free at 800-252-9108 or by video phone toll free at 866-362-2851 or by visiting www.drtx.org/choices. This video was brought to you by Disability Rights Texas. Find us on the web at www.drtx.org. Financial support for this video is provided by the Texas Council for Developmental Disabilities, with federal funds made available by the U.S. Department of Health and Human Services.
All right, so we just saw Ricky's story, and it looks like, it showcases the differences generally between guardianship and supported decision-making. So it sounds like in Ricky's case, supported decision-making was the right choice for him. However, guardianship might be the right choice for other folks. So I'd like to come to you, TK. Can you tell me a little bit more? Because I know y'all's role in the Guardianship Office and HHSC is different than what people might think generally what guardianship is. So can you tell me a little bit about the HHSC role in guardianship services? And more specifically, does HHSC obtain guardianship for anybody who needs one?
Well, no. So HHSC is statutorily designed under Chapter 48 of the Human Resources Code to accept referrals from Department of Family and Protective Services, specifically CPS and APS. Child Protective Services makes referrals of individuals that are already in their conservatorship, that are age 16 years of age and older, and for whom the department believes that because of a mental or physical disability would be unable to provide food, clothing, or shelter, be able to manage their own personal health affairs or manage their estate. APS refers individuals who are in a state of abuse, neglect, or exploitation who they believe is incapacitated per the Estates Code definition in Section 1002. So basically, when we get a referral, a guardianship specialist or another staff will go out and make an assessment to determine the eligibility and appropriateness for guardianship under Title 26, Chapter 361 of the Texas Administrative Code. And then we go out and, in general, we make sure the individual is indeed incapacitated per the Estates Code definition, and we assess the risk of imminent harm or the threat to them or their estate, what would happen if a guardian was not appointed. And we look at the likelihood of if a guardianship would actually be an effective remedy to their needs. We also look at lesser restrictive alternatives, such as what Cicely mentioned, the supportive decision-making forms, power of attorney. Because guardianship is the most restrictive and it has to be granted by a judge, we don't do that lightly. We make sure there are other lesser restrictive alternatives. And then HHSC does not take community referrals or from other state agencies. In very limited situations, we are able to take a referral from a court that has probate jurisdiction.
Great. Yeah, thank you, TK. I think that clarity, that last part, is really important for folks to know what y'all's role is, to not send referrals necessarily to HHSC guardianship.
Exactly.
So I think that's really important, especially within kind of the HHSC service array and understanding what those limitations could be. Kent, I want to come back to you. You had mentioned that I think you had mentioned in the introduction that you had worked with the local IDD authorities or LIDAs. I know this group is commonly very, very familiar with the LMHAs on the mental health side. So can you explain a little bit about what the LIDAs are and how they support individuals and families with decision-making opportunities and kind of what those different things might look like when they're exploring that stuff?
Yeah, absolutely. So like the local behavioral health authorities, and they serve all the counties in Texas, we really have the same situation with the LIDAs. Almost all the LIDAs are under the same organization as the local behavioral health authority. And so some of them cover one county, some of them cover multiple counties. And so with the exception, I think, of Bexar County, those are all the same organizations. So, but when we think about the LIDA, they have some primary responsibilities. They are what we call the single point of access. They do intake and access for all these IDD services within the county that particular LIDA is responsible for or has authority for. They have other responsibilities. Luckily, gosh, I don't know, 10 years ago, all the LIDAs received some crisis funding. So you'll see different kinds of maybe crisis respite or crisis intervention specialist. There's also a team, or actually about 8 teams across the state called transitional support teams. But the LIDA, at the front door, they're talking to people about their rights. They're talking to people about the general revenue services that they get, which is basically the state dollars that particular LIDA has to serve people in those communities. But then they're also talking to people about Medicaid waiver programs, and as y'all know, there's certain interest lists for those. But part of that process, at the front door and at least annually, we're also talking to people about their rights. And we're also talking to people about the different decision-making options. And so guardianship, supported decision-making, all of those things are discussed and with the person and the family. But you know, if you think about even with person-centered thinking, one thing that's been really positive, I think, for many years now is we've built in those decision-making supports within the training that all service coordinators receive, because anyone in IDD services that's in that particular county of the LITA, if they're getting services, they have a service coordinator, and of course that person is who's talking to them and helping them access services, they're monitoring services, but they're also making sure people are able to exercise their rights. And kind of going back to what I mentioned earlier, you know, with person-centered thinking, they're helping people develop a person-centered plan. So we're really identifying, you know, what kind of supports do people need? And also, what are their dreams and hopes and those things that they want to accomplish? So it's really not too unlike behavioral health services. I think one thing, and Cicely kind of reminded me of it a little while ago, when this particular legislation was passed 7 or 8 years ago, disability rights was very involved in training across the state. And I was working at ALITA. We served 19 counties, but they had a particular one of their staff that would come around and help train all of our service coordinators, providers. And so it really wasn't until then that I think that people understood they have options, because like even back when I was a service coordinator back in the 90s, it was, you know, we would be working with families and the school district or somebody would, you know, say, well, your child's going to be 18 soon. You really need to look at guardianship. And this would be a person that might get a job or might live independently. And, you know, I don't think then we really didn't have all the options we have today. But I think it's really cool or neat that now when we do explain those options, you know, the positive thing about it is that the people we serve are able to maintain their rights to the most possible and have that positive control over their life.
Yeah, I think that's a theme that we're seeing a lot throughout some of the sessions in the conference, is really taking a step back, assessing that person, their needs, kind of where they want to go, what that looks like, and really taking, you know, them into consideration, even when things come up like decision making. There isn't this unilateral decision that if you were a person with IDD, then you must have a guardianship. I think that that's definitely maybe a former way of thinking about things, and we're starting to really think about what else is possible. And I think the supported decision-making legislation was really monumental in pushing some of this stuff forward, that may have already existed before in little pockets here and there, but it definitely was truly codified when that legislation went through. I want to, you know, switch back to something that might be more relevant to some of the folks in the audience, and really talk about how these concepts kind of interact with things that could apply for judges and lawyers, and when they're kind of coming into courts and folks are coming into their courts and what that looks like. So I want to come back to you, Cicely. So if I'm a judge and I'm approached and I'm being told that this person needs a guardianship, what are the types of things that I should consider as a judge? What are questions I should ask? And why is it important for me to even do so?
Right. So the reason why it's important for judges to really ask questions and probe and weigh the evidence in these cases, quite simply, is because the law in Texas now requires it. And under Chapter 1357 that we talked about earlier, all judges in Texas are required to consider less restrictive alternatives before placing someone into a guardianship. So it's really important that judges are armed with the training and the tools that they need to sort of think about these questions when they're evaluating a petition for guardianship. So thinking about, you know, if you're the judge and you're being asked to place someone into a guardianship, prior to doing that, you want to think about, what is this individual's specific disability? What caused the disability or associated impairment? Is there associated impairment? Is there a lack of is the lack of capacity or the diminution in capacity, is it temporary or is it permanent? What is the probability that this individual will improve or gain capacity in the future? Does this individual have access to community and supports and services, like what Kent was referring to? Does this individual have close family, friends, neighbors, individuals in the community that can assist them with their needs? Is safety an issue? Is exploitation an issue? What role can technology play in assisting this individual? And I think that's really an important question in 2022, because we've come so far in advancement in terms of technology tools that are helpful to individuals with disabilities. There are so many different assistive technology devices, apps, programs, different things that can be utilized and leveraged. Whereas, 20 years ago, 30 years ago, a lot of these things were not possible. What role can technology play in assisting and supporting this person is a huge question that needs to be evaluated in every case. Which rights can be carved out or preserved? So particularly when we're thinking about young people, when we do these agreements, and we've done hundreds of them since 2015, one of the primary questions with transition-aged youth in particular is, their ability to manage finances, their ability to manage their educational progress, their ability to manage their vocational decisions. So when you place someone into a full guardianship, then the guardian is going to be making those decisions. If this is a young adult that literally just specifically needs support surrounding making decisions about education, or support surrounding medical decisions, or support surrounding financial decisions, applying for benefits, things of that nature, well, you don't need to put anybody into a guardianship for that. You can do a power of attorney, a medical power of attorney, an educational power of attorney, a durable power of attorney, to give that young person the support that they need so that they retain their right to vote, they retain their right to work, they retain their right to learn how to drive, to get married, to do all of the other things, that we expect our young people to do, when they get older. So really looking at these less restrictive alternatives and how they can fit in to a comprehensive solution for this particular individual. So judges need to be asking the question, what does this individual need support with? What are the action items? What are the things that this person needs to live safely in the community with their non-disabled peers? Which rights can be carved out and preserved? Which rights can be restored if conditions improve? Sometimes with individuals with disabilities, they become temporarily incapacitated. I've worked on cases where we've had clients that are in a coma. In a medically induced coma. Well, this is not somebody that needs to be in a guardianship for the rest of their life. Just while they're in this incapacitated state, they may need some assistance, they may need a guardian, what have you, but this is not something that's going to persist for the rest of their lives, right? So really thinking about this individual's specific impairment, this individual's specific lack of capacity, and what that looks like for this person. And what things or tasks does this individual specifically need support with? And so when you start looking at the case, as you start looking at the individual as a person and not a case on your docket, and thinking about a personalized approach, a person-centered approach to coming up with a reasonable solution for each individual person, that's how these less restrictive alternatives really come into play. And every judge should be looking at these really carefully and really evaluating the evidence that's being presented to you to determine if this person really does belong in a guardianship.
Absolutely. And I wanted to follow up on something that you had kind of teased on a little bit and started to talk about it, was this idea of being able to determine what rights might still be applicable. So if there is a guardianship or restrictions that are put in place, what restrictions make sense for that individual, and and really, or are you able to kind of customize some of those rights and some of those restrictions? So I wanted to ask kind of a follow-up question a little bit to dig into what you had just mentioned, Cicely, about is guardianship an all or nothing? Is there with a temporary or a limited guardianship, what does that look like? And then also, and I think you might get into this a little bit, but even under a guardianship, does that person still have any rights? I think there might have been something associated with the legislation that came out that even with the guardianship, there's still something there that's important to know. So can you expand on that a little bit?
Right. So it's important to note that even when judges are looking at placing an individual into a guardianship, there are different varieties of that can take place. So like, for example, a judge can grant what's called a limited guardianship or a partial guardianship in cases where the individual with a disability still has the capacity to make most of their major life decisions. Nevertheless, they may need, specific help with certain complex matters. So when we look at like a limited guardianship or a partial guardianship, financial and medical are the most common. I'm going to place you into a guardianship specifically just for the purposes of financial. And everything else, the individual with a disability retains their right to make decisions as far as that goes. So with every arrangement, whether it's a supported decision-making agreement or a guardianship, there's a Bill of Rights that's incorporated with all of that. The law presumes that everyone has the right and the individual freedom to make their own decisions. So when this petition is filed and a guardianship is sought, they have to demonstrate via the evidence that they're presenting that a guardianship is required for these specific matters. So the power of the guardian is limited, just depending upon the circumstances on a case-by-case basis. So individuals that are placed into a guardianship still have certain rights. They can still request all of the paperwork and the docket and all of that that's associated with their case. They may have an attorney ad litem or a guardian ad litem during the pendency while the judge is making the decision about whether or not to place them into a guardianship. They have a right to access information. They have a right to ask questions. They have a right to retain an attorney if they're in a guardianship and they want it to be modified or terminated. They have a right to access the courts and retain an attorney to go in and do a modification or a restoration of rights, if you will. And there's also court oversight that's involved in guardianships. So every year, in order to maintain a guardianship, the guardian has to check in with the court. There has to be a full inventory that's taking place in terms of financial resources of the estate of the ward. So all of these things are going to be checked into and evaluated on a yearly basis. And so if this process isn't kept up with, then the guardianship lapses, right? So there are still rights that individuals retain even when they're placed into a guardianship. That doesn't give the guardian 100% full control over this person forever and ever and ever, into infinity. So it's not always necessary to place someone into a full guardianship. There can be partial guardians. There's can be a limited time frame. So maybe somebody needs to be in a guardianship for a year, or 6 months, while they recover or whatever the case may be. So again, judges have to exercise an extreme amount of care and a very narrow sort of discretion, if you will, in looking at these cases, because literally our law in the United States assumes that everybody has the capacity to make their own decisions and individuals have individual freedom. So when we're talking about taking away someone's individual freedom, particularly an individual with a disability, that is not a decision that should be entered into lightly. It's not a matter of a family member going and get an affidavit from a physician saying this person needs to be in a guardianship. That is not sufficient evidence to place someone in a guardianship just because, a son or a daughter or whatever gets an affidavit from a doctor and says, okay, they need a guardianship. Judges are now required under Texas law to probe deeper than that to figure out, does this person really need a guardianship? What are the supports and services that are available in the community? And how can we tailor an individual solution for this person? So that is what the law requires. And so that is what the judges are going to have to do. Simple as that. Yeah.
That was a great rundown. I love that. All right, we wanted to end our session with another video clip. It's the story of Jenny Hatch. It's a quick news clip about a woman named Jenny Hatch, and it illustrates some of the things that we talked about today, about a person with a disability choosing some of those decision-making supports and what that looks like. So can we roll the video too, please? Oh, we don't have that one? Okay. All right. Well, it's on YouTube, so I would say check it out. The Jenny Hatch story. It's a little CBS News clip. A little bit of a spoiler alert. Jenny Hatch, I think she was under a guardianship. And then her parents kind of took a step back and said, wait a minute, there's some different options. Kind of what do you want that to look like? And Jenny, was able to then choose her own guardians. I think at some point her parents were her own guardians.
Yeah, her parents were trying to get a guardianship over her, and Jenny did not want her parents to be her guardians. So Jenny hired an attorney, and they went to court, and Jenny was able to successfully get what we now know as supported decision-making with some trusted friends in the community. And so Jenny was able to avoid being placed into a guardianship. So that sort of launched the Jenny Hatch project, which if you go to the DRTX website, we also, under our supported decision-making materials, have a link to the Jenny Hatch project and Jenny Hatch's story. But Jenny's story was interesting because she literally took control of that process and said, I do need help, and I do need support in making decisions for myself. But I also want to retain my right to control my own destiny. I want to make certain decisions for myself. I think she wanted to continue to work. She wanted to get vocational training. So it's a really interesting story, and it really sort of launched a movement, which culminated in Texas with the Estates Code being amended. So.
When I think did she ultimately choose to stay in a guardianship? She just was able to kind of choose what rights she retained, what those guardianships looks like, and then the opportunity to change that in the future if she wanted.
Right. So I can't remember if she remained in a guardianship or if they came up with another sort of legal solution for her. But she was able to, the broad stroke is that she was able to get the support that she needed and not have to be in a guardianship. So there's, he's got it.
Oh, we got it.
Excellent.
All right.
Okay.
Well,
Cool.
No, we were just teasing
Let's
it.
take
We
a
were
look
just
at
kind of
now
setting it up.
That was the preview. Yeah.
Excellent. Oh, no, that's not the one. Yeah, sorry.
Yeah, that's the same one.
Yeah. All right. Well, we were just about go to the website, check out the YouTube. And I think that's it for us. We wanted to move to questions. It looks like we've got a couple. Go ahead.
Sorry. Thank you so much. Maybe we can still find that video, but in the meantime, an online question came in. Can you modify a full guardianship to a limited guardianship at a later date? And is that hard?
You can modify a full guardianship into a limited guardianship at a later date, but it has to be after 1 year has gone by. They can't be modified, or guardianship in Texas can't be modified or changed within that first 12-month time frame. So once 12 months has gone by, you can file what's called a motion to modify, or you can file a petition for restoration of rights. And then the process essentially starts over. So you're going back to the court, you're going back to the judge, you're presenting new evidence, you're presenting, evidence that supports the idea of the guardianship either being terminated or modified based on, current conditions, right? So, and this happens typically, the example that I usually give is I've had clients that have been incapacitated due to a medical condition, and they start undergoing medical treatment, and as the medical treatment advances, they gain more and more and more of their functionality and their capacity, and so after a year and a half goes by, they don't need a guardianship anymore because they've gone through the rehabilitative process and they're ready to sort of step back into that role. So it can definitely be done. Is it easy? No. You're going to have to, at that point, probably retain an attorney, and you're going to have to present evidence. So it's a little bit of a complex process, but it can be done.
And we do have individuals periodically who contact the judge and request to have their guardianship dismissed. It's called restoration. The judge will appoint an ad litem to work with them, and we've had several from our program that have had their rights restored. A lot of them are the individuals that CPS referred, because They come in, they're not taught the things they need to know, and along with socialization and continued support from different facilities, that they are able to learn the things they need to live on their own without a guardianship. And we're all cheering when that happens. It's a very positive thing.
All right. Do we have a question in the back? Okay, I'm going to repeat it back just so folks online can hear it. So the question is essentially, and let me know if I mischaracterize it, when someone chooses a maybe informal decision-making support like a supported decision maker, is there any kind of vetting process or, you know, understanding who that person's going to be before that decision is officially made?
Right. So, you know, in the context of a guardianship, if a court is granting a guardianship for an individual, then there's a process built in with the court. There's information that has to be provided. Some courts will do a background check, things like that, to determine, you know, whether or not this person is the right person to be a guardian. In the alternative, when we draft supported decision-making agreements for our clients, typically what we will do is interview the client first, and find out from the client what they need support with, and then interview the proposed supporters. So I would say when we do supported decision-making agreements for transition-age youth that are turning, you know, they're moving from being 17 to being 18, in probably 80% of those cases, the supporter that the young adult selects are their parents, one or the other parent. And so that process involves just sitting down with the parents, sitting down with the young adult, and really talking through what their needs are going to be once they turn 18. And it's an integrative process, right? So when we think about a young adult transitioning into adulthood, you know, we think about that wraparound package of services, which is we've talked about that a lot in the conference. So thinking about vocational training, thinking about, you know, applying for benefits and things along those lines. So the supporter is typically someone that the individual with a disability trusts, someone that they know well, someone that knows them well, somebody that understands the intricacies and the complexities of their specific disability and understands how to support this individual, right? Because every individual needs a different type of support, a different flavor of support, a different brand of support. So the most important thing for the supporter is to really understand their capacity and what they need to do to support this person so that they are living the best life that they can live. So the qualifying factor is really just looking at what type of support the individual needs and whether or not the supporter is capable of providing that support. And then supported decision-making agreements along with guardianships are all subject to the same monitoring system in Texas. So, you know, you mentioned adult protective services. So all of these agreements, whether it's a guardianship or a supported decision-making agreement, they're all subject to being scrutinized and evaluated in terms of abuse and exploitation. The reporting process is the same. So we want to make sure that, and those protections exist. So the supporter also needs to understand that you have a fiduciary duty to this individual that you're supporting. And so you're not going to be able to get away with exploiting this person or, you know, exploiting them financially or whatever the case may be. So those protections are still in place, whichever option a judge chooses.
And plus, a supportive decision maker can also, the individual can revoke that agreement with that person. You want to speak on that?
Right. So supported decision-making agreement is an informal agreement. So it doesn't require that you go to court. It doesn't require necessarily that you retain an attorney. And the agreement exists for as long as the parties to the agreement want it to exist, right? So, you know, if they embark on this journey of supported decision-making and as it turns out the supporter is not so supportive, then, you know, they can choose someone else and substitute them out and kind of try different things until they land on, you know, what works best for them. at 1357, and you can also go to our website, www.drtx.org, and under resources, there's a tab with supported decision making, and we also have our toolkit and our materials outside after the presentation. So if you want some stuff to take home with you, meet me at the table, and I can give you everything you need.
We have about 20 seconds. One last question. Go ahead.
Okay, how is that supportive agreement enforced?
So it's basically enforced in that the parties are just sort of living up to it, if you will. So, for example, if they have a supported decision-making agreement and a release of information, if the young adult is still in high school, and they have an ARD meeting, let's say, then the parents would come to that ARD meeting along with the young adult, even though they're over the age of 18,
Right.
with the supported decision-making agreement and the release of information, and the parent can continue to participate in that ARD process with their young adult, even though they're over the age of 18.
And so if it's a person, let's just say that's 40, and they enter into the supportive decision-making agreement with a parent or friend or other family member, and then that person oversteps or does something, I just want to know how to protect the person since it's not, judge or court ordered.
Right. So with an individual who's an adult, like 40, whatever, typically, if they have a supported decision-making agreement with a family member, they will go to, let's say that family member is going to support them in their medical treatment. So they'll take the supported decision-making agreement and the release of information to the doctor's office, inform the doctor that, hey, this is my supporter, they're here with me to help me make decisions, here's the paperwork, keeping that on file. And if at any point in time the individual with the disability feels as though they're being exploited or whatever the case may be, then they can simply terminate the agreement and seek an alternative arrangement to that in terms of what support they will need in the future. And if anyone suspects abuse or neglect, it's the same process. So whether somebody's in a guardianship or whether they have a supported decision-making agreement, if you're a caregiver and you suspect abuse or neglect, then you report that to DFPS, and that starts the investigation process. So
TK
the
has
protections
one
are
more.
the same.
I
Yeah.
also have an adult guide to guardianship that I will put out here for you. You can take with you. It's in English and Spanish, and it covers some of the supportive decision-making rules and other alternatives to guardianship. So
Wonderful, wonderful panel. And Judge, I'm going to have to interrupt. We have the ability to see these individuals, person-centered authorities on this at a wonderful site called Rock House of Stephenville. They are so respectful of the individuals. They go on dates. They go to Dallas Cowboys games. This is what you all have worked to achieve, and thank you. My hat is off to all of you. Thank you so much. Well done. Well done.